Having had an opportunity to analyse this document, I can say with some authority that this is the most draconian legislation that I have ever reviewed, having challenged significant emergency legislation in recent times. As a human rights lawyer, I would describe it as spine-chilling. Upon reading the proposed legislation, what struck me was the Health Minister's foreword, in which he states that the new health protection legislative framework will be based on a review of the 1967 Act and the recent public health emergency. I would suggest that no consideration has been given to recent public health emergency, other than the fact that the former Health Minister deemed he did not have sufficient legislative power or authority to take measures further during the previous public health crisis. This is notwithstanding the significant legal challenges that the Minister, his department and other agencies faced as a result of their actions. In the document, it states on numerous occasions that it is intended to progress the bill at pace. This in itself is quite a concerning statement, given the fact that ordinarily any bill of such a nature should be analysed and toiled over in good time. It also reiterates the narrow scope of the Act, which is contradicted by the substance of this document and therefore the proposed legislation. It also states that an outside international body has largely drawn up this legislative framework. This in itself should raise eyebrows. What is also given reference specifically is the power of entry and the role of authorised officers, which came under significant scrutiny in the Divisional Court in the judgments of Kozubakova and Hughes. The proposed legislation centres on a 2015 consultation and refers to public health threats that are yet unknown. This would be, in essence, akin to framing terrorist legislation against an unknown threat. Moreover, other legal issues arise in respect of the potential implementation and procedural processes of the administration of this legislation, if this legislation is passed. Not only does this legislation give rise to a veto over ministers, but the Assembly itself to enact certain measures. Yet this proposed legislation heavily engages numerous convention rights, including Article 3, 5, 6, 8 and 10. It also flies in the face of significant case law and the guiding principles that are the cornerstone of our legal system. Lastly, there are serious questions in respect of the standing of this proposed legislation in reading it in line with the Good Friday Agreement. In conclusion, I have grave concerns in respect of, firstly, the process of consultation, and secondly, the content of this proposed legislation.